be talking about some jurisdictions that include written provisions protecting the interests of animals, but my focus is really going to be on what constitutions don't say about animals that is important to understanding their place in constitutional polities. So Robin West has reflected, among others, that jurisprudence is, after all, about human beings. And her point in making this observation is that law makes certain assumptions about the nature of the human person at its center. And this is part of a vast literature about the nature of law's person. Much less examined is the question of whether law is ever for or about non-human animals. And if so, who is the animal that law is imagining? So there is increased attention to this question across a number of fields, including in particular constitutional law. And this usually is connected to the fact that there are an increasing number of jurisdictions that have adopted actual textual provisions protecting the interests of animals. So we have a handful of global jurisdictions listed here: Switzerland, India, Brazil, Slovenia, Germany, Luxembourg, Austria, Egypt, and Russia, who have actually adopted provisions in their constitutional texts directly attending to the interests and concerns of animals. So in past work of mine, I've discussed the origins and interpretations of constitutional animal protection provisions across these very diverse jurisdictions. And I'm happy to return to some of that in the Q&A. But since my focus today is on unwritten constitutional principles, I'm just going to pause here briefly to give those who are unfamiliar a sense of the flavor of what these textual provisions include. So one example is Brazil's constitution, which places a burden on the state to prohibit all practices that subject animals to cruelty. In India, there is a constitutional duty placed on all citizens and on the state to have compassion for living creatures. And Switzerland uniquely places a duty on the federation to take account of the dignity of living beings. So what I want to suggest today is that to truly understand the place of animals in these constitutional orders, we need to look beyond these specific texts and their explicit interpretation. And to this end, I suggest that we think about animals in what we might think of as the invisible constitution. So the invisible constitution is a concept developed by Lawrence Tribe in the US context, further developed by Akil Rita-Mar of Yale in terms of the unwritten constitution of the United States, but also brought by Dixon and Stone, among others, into the field of comparative constitutional law to describe elements of constitutions across a number of systems, even outside of the United States, elements of constitutions which are not written or which are otherwise invisible. So as Dixon and Stone explain, this concept of invisibility can have at least a couple of different dimensions. One is that we're talking about things that are outside the text. These are extra textual features of the constitutional order. And another possible aspect of this invisibility is that these aspects are unperceived, often even by actors within the constitutional system. But even though we're talking about parts of the constitutional order that are extra textual and unperceived, possibly even by actors within the system, there's still a drive and theoretical impetus for thinking about these as nonetheless being parts of the Constitution itself. And this is distinct from the notion of constitutional law, which captures the interpretations and jurisprudence of the day, or constitutional culture, which captures widely shared understandings or fundamental norms that guide public law relationships. Here, we're talking about things that are actually part of the Constitution in the sense that they are essentially stable, that they are core and central to the life of the polity, and that they take the form of principles or requirements that effectively bind actors within the system. Of course, the boundaries between what counts as part of the invisible Constitution and what we should properly think of as constitutional law or culture are contested. But nonetheless, we can keep in mind this distinction that there are some parts of our constitutional lives that represent parts of the Constitution, even though they are not part of the constitutional text, and even though actors within the system might not be aware that they are being so bound. So a lot of the literature on this idea of an invisible or unwritten constitution paints a really pretty picture of what these unwritten elements are. There's a really positive notion of what's included here. So in Tribe's development of the invisible constitution, he lists things like judicial review, popular sovereignty, legality, among other principles. In Granville Austin's influential account of constitutionalism in India, democracy, social revolution, and national unity are listed as having a similar function. And within Canada, my own home jurisdiction, the Supreme Court has identified a number of what they refer to as unwritten constitutional principles that include things like democracy, rule of law, minority protection, and federalism. So much of the debate within scholarship on invisible or unwritten constitutional principles are institutional in nature. So the question isn't, are these things good or bad, but which parts of government do we most trust to protect them? Is it the purview of the court to protect and defend unwritten constitutional principles, or is that task better left to legislative or executive branches? So what I want to suggest is that in order to understand the place of animals in our constitutional system, we need to revise and rethink this approach to unwritten constitutional principles. And we need to make room for an understanding of unwritten constitutional principles or invisible constitutions that are less sanguine, less pretty. So I want to turn to one scholar who has offered very briefly, sort of in passing, a swipe at the Supreme Court of Canada for their articulation of these vaunted or positive unwritten constitutional principles. Tompkins, who has said, wouldn't it sadly be more accurate to say that a constitution dating from 1867 is more likely to be based on principles of elitism, racism, sexism, and imperialism than on the four good things that the Supreme Court identified, being democracy, rule of law, minority protection, and federalism? So following Tompkins, we can think about a reorientation in our thinking about what the unwritten constitution might include. This shift in orientation lets us think about elements of our constitutional system that share this stable, foundational, and principled quality, but that are hierarchical in nature as opposed to egalitarian, that are disreputable or contested, at least at the margins of the polity, as opposed to being things that are held dear to courts and their audiences, and that are polyvalent, that they don't just operate synergistically together to create a system that works harmoniously, but that it may be that a feature like rule of law is a stable foundational core principle within a system at the same time as some other more hierarchical principles may push in the opposite direction. So I suggest that this revision in our thinking about unwritten constitutional principles or the invisible constitution is actually necessary in order to understand where animals sit in our constitutional legal orders. And this is because I will propose that across a number of constitutional orders, perhaps even in some degree all state constitutional orders, there exists something like an animal exploitation principle. By this, I mean a principle that suggests that animal use, in particular killing of animals for any non-deviant human interests, is prima facie acceptable. And this principle that I'm articulating here has a constitutional nature in the sense that it is stable, it is core and foundational to the way our polities operate, and it is a principle in the sense that it limits the possibilities for legal interpretation. So appreciation of this principle can help us make sense of a certain kind of radical functional critique that's been leveled at constitutional animal protection provisions. So many scholars have looked at this list of jurisdictions that claim to protect the interests of animals and said, well, how can it be that these principles are, that these provisions are effective if animals are continuing to be slaughtered and instrumentalized across these jurisdictions? So some of these critiques have included, for example, Aaron Gordillo in Brazil, saying that the fact that in Brazil you can kill and capture animals makes a mockery of a constitutional provision that promises to protect animals against cruelty. And in Switzerland, Jerry Bolliger has proposed that the lack of a life protection for animals is a contradiction of the dignity concept that is set out in the Constitution. So these kinds of criticisms really are at stark contrast with the legal realities of constitutional animal protection in these jurisdictions. So in Brazil, for example, the actual jurisprudence, the cases that are being considered by the Supreme Federal Tribunal are almost exclusively focused on large public spectacles of violence towards animals. And this is in a context where there are large animal use industries and animal use is pervasive and not in the jurisprudence considered to be in conflict with the existence of this constitutional protection. In Switzerland, similarly, we see the High Court jurisprudence focused specifically on questions relating to animal experimentation, again, in a context where there is pervasive animal use, in particular where animal products form a very large component of Swiss diets. And again, this is not thought of within the jurisprudence as being in any way in tension with the protection of the dignity of animals. So there's a number of ways that we can think about this radical critique, this notion that these principles are necessarily failing as long as they allow killing and instrumentalization of animals. So one way we might think about this is to accept that critique and say that these provisions are in fact failing. And we do have within comparative constitutional theory some different ways of thinking about what it means for a constitutional provision or a constitution to just not keep its promises. One way of thinking about it is to suggest that these provisions are shams. But unfortunately, for this theory, the idea of constitutional animal protection provisions doesn't really fit within the existing explanation of why we see sham provisions in constitutions. Generally, our understanding of sham provisions is that they exist where countries make big promises of fealty to constitutional ideals that are widely held in order to present themselves, usually to international audiences, as sort of good constitutional citizens. But animal protection doesn't really fit this bill. First of all, because it's hard to see what's actually even being promised by these provisions. This isn't something like a prohibition on torture, where there's widely held although there's disagreements on the margins, there's a widely held shared understanding of what it means to torture a human being so that you can test whether a country that has promised not to torture is in fact engaging in torture. Where a country says that they're going to protect animals from cruelty, this is a famously contested term that doesn't have shared meaning across jurisdictions. So it's very hard to say whether a country is making a grand promise that they're then not keeping in some sort of international terms. But on top of that, the general thought behind sham constitutions and sham provisions is that their aim is to persuade international audiences that a given country is a good constitutionalist citizen. But given how rare constitutional animal protection provisions are, it's hard to imagine that a country would include an animal protection provision for this reason. It just doesn't fit the scripts of global constitutionalism in the way that, for example, a prohibition on torture might. So even if we think these provisions are not shams designed to fool global audiences into thinking that a particular jurisdiction is more constitutionalist than it actually is, we might think that these provisions fit within the framework of aspirational or transformative constitutionalism. And this tends to describe constitutional provisions that set out a commitment that is greater than the state is actually meeting, and that all parties understand exists in order to guide a path to transformation over time. So the paradigmatic example is social and economic rights in South Africa, where we have a constitution that promises, for example, access to adequate housing in a context where large proportions of the population are unhoused. And the court understands that what is being promised is a commitment to transformation over time. And it's not thought that this is a sham provision designed to deceive, but instead that the gap between reality and practice is one that is understood to be temporal, and that a forward-looking vision of this provision helps us to understand its meaning. Again, this doesn't seem to fit the picture with constitutional animal protection. So I have argued in previous work that I think it would be a good thing for constitutional courts to think about animal protection provisions as transformative or remedial, as intervening to try to change the status quo relationships between human and animals. But even when I put forward that proposition, I had to admit that no courts or legislators seem to be thinking about those provisions in this way. The overriding narrative or paradigm is one of balancing of human and animal interests, not one of radical transformation over a long time horizon that requires some kind of aspirational approach in order to achieve. So our general explanations for provisions that fail to do as they promise don't really seem to fit the bill here. We might think then that these radical criticisms of these provisions as failing because they allow the continued killing and use of animals as being what Yale's very own Jack Balkin has called an off-the-wall interpretation. And in this case, perhaps something more like constitutional idealism, which Balkin has used to describe constitutional interpretations, which express something closer to what the speaker wishes or aspires to have the text be, and that are sufficiently unmoored from the actual constitutional practice and text in the jurisdiction, that it's more an act of idealism than of interpretation. But what I want to propose as an alternative here is that we might think about this radical functional critique not as proof that these provisions have necessarily failed or that the critiques themselves are simply off the wall, but instead that these provisions might represent, or these criticisms might represent something like a challenge to the invisible Constitution. So what do we get when we start thinking about these criticisms not as off the wall or as devastating to our understanding of the effectiveness of these provisions, but as critiques of the invisible or unwritten Constitution? So this approach locates this kind of radical critique within rather than outside of constitutional theory. And in this way, it invites a certain kind of interdisciplinarity into comparative constitutional analysis that I think is sometimes wanting. A lot of the scholarship within comparative constitutional law that focuses on interdisciplinarity talks about the need to bring in the tools of social scientific method, particularly political science. But there is much less concern and much less presence of another kind of interdisciplinarity, which finds room for critical theory within comparative constitutional interpretation. And thinking about contests to the invisible or unwritten Constitution allows us to bring in those more critical analyses and voices as part of our understanding of comparative constitutional law. And the benefit of that is that it allows us to take these critical theoretical approaches and apply the benefits of comparative law method to our assessment of these kinds of claims. So critical theoretical approaches often talk in broad interjurisdictional terms, where comparative legal method really urges us to attend to what's particular in a jurisdiction versus what's generalizable to which sets of jurisdictions, et cetera. And so, for example, as Rosalind Dixon has urged, there is space for what we might think of as iterative or concentric studies, where experts in particular jurisdictions can give close analysis to the particular instantiation of broad theoretical claims along the lines of what I'm offering here today. So I want to conclude by offering some normative objections that I anticipate and feel within my own heart as I set out this analytic program. So I think of these as some interlocking giving up the ghost objections, giving up the ghost for animals and for people. The first of these takes the form of this objection. Maybe it is true that there are unwritten constitutional principles of animal exploitation across jurisdictions. But even if that's true, why would we admit it if we want to protect animals' interests? Wouldn't it be better to just focus on the fact that there are more jurisdictions, including animal protection provisions, that even in jurisdictions without constitutional animal protection provisions, there's increasing evidence of attention to animal interests, for example, within proportionality analyses. So why wouldn't we just focus on those positive developments instead of turning our attention to the idea that there is some underlying principle that will thwart more radical transformation? And on the other side, are we giving up the ghost for people? If we start lumping in hierarchical, ignominious, and disreputable principles with these good things like rule of law and democracy, which we see as being these fundamental, stable core elements of constitutional systems, aren't we diluting or degrading by association these positive goods? So my answer is ultimately that your take on these objections is going to depend on your assessment of the value of critical theory more broadly. My own view is that the idea of an animal exploitation principle operating in a number of different jurisdictions has a lot of explanatory power. And I think this explanatory power extends beyond the animal protection context to help us understand the systematic nature of hierarchies. To understand these not as blips or deviations from constitutional systems that are essentially egalitarian and just, but actually as part of those systems themselves. And relatedly, to understand that constitutional forces have this polyvalent quality, that we're not just looking at good principles operating in synergy, but that there are ignominious or disreputable principles just as actively in the mix, structuring constitutional relationships. And it invites deliberation at the level of principles. Once we start thinking about the basic principles of our Constitution as including not just positive elements, but also these more disreputable elements, it allows us to start a conversation about what are the good and what are the bad parts of our stable core constitutional orders. So I focused here on the animal protection or animal exploitation principle that I'm suggesting exists in a number of jurisdictions, but I'm talking to a largely American audience. And so I want to tap in as a closing thought to what the broader implications of this theoretical framework are, and invite you all to think, if we thought that the United States Constitution included not just good constitutional principles of the kind that Lawrence Tribe has identified, but also ignominious constitutional principles that are core, stable, and foundational, and shape the life of the Constitution, what might those be? So I will leave that as an open question for now. And I do actually see a number of Canadians in the group. So I'll also say I have asked this question about Canada as well. I think in either jurisdiction, there are some interesting answers to that question. So thank you so much for taking the time to join me in this presentation. And I really look forward to hearing your thoughts and questions.
Wow, thank you, Professor Eisen. That was a really stimulating and fascinating presentation. And I just think this project is going to be incredibly yeasty, generative. So the one question that I would like to start by asking, but before I do that, let me invite everyone who's participating. Feel free to use the raise hand button on Zoom, or if you prefer, you could drop your questions and comments into the chat and I'll relay them to Professor Eisen, whatever you feel more comfortable with. So the thought I had as you were laying out this framework was that it maybe it would benefit from adding in a temporal dimension. And here's what I was thinking. Down south of the border in the United States, we had a constitution that was ignominious from the very beginning, right? Because it was established explicitly on racial hierarchy. So one of our unwritten principles was white supremacy and black subordination. That was part of our unwritten constitution, but it was also, it had textual instantiations as well. And then, of course, we fought a horrible, bloody war to try to change that. But then after the Civil War, the the explicit written amendments that purported to abolish slavery and purported to give equal protection under the law, are grossly under enforced to this very day. And so there's a way in which the unwritten constitutional principle of white supremacy kind of coexists with this new principle of racial equality. And you can think of the, various battles about our voting rights acts to this very day as being, in some sense, shadow boxing matches about those unwritten constitutional contests. So I guess what I'm wondering is, could we tell a similar story about the express animal protection provisions in constitutions that they come and they try to pronounce through formal, legalistic, textual means? They try to pronounce a new constitutional order, but of course there's going to be lag within the society, and that unwritten exploitation principle for animals is going to continue to exert a great amount of force. So discuss.
Yes. So I think that's exactly this sort of tension that I'm pointing to and hoping to draw out here. And lest some audience members think that my vision of constitutionalism is colored by thinking that Canada has some kind of pure constitutional history. We also have a constitution that was created for the purpose in Canada of more directly subordinating Indigenous legal orders and the taking of land. This was an absolute express, not secret reason for creating Canada's constitutional order. And that, again, remains with us to this day as a complicated part of what the country is and does. And so I think this idea of you identified this really interesting narrative of white supremacy as something like a founding principle that now exists, or I don't want to put word in your mouth. I would suggest it continues to exist within the United States as a part of the constitutional order, but that exists in tension, or what I describe as polyvalent relationship with other principles like equality that have been since sort of brought more to the fore through constitutional amendments, but that there is still an ongoing unresolved battle at the heart of the unwritten constitutional order, and that debates as to which of those should prevail in a given case are the kinds of principled debates that let us see what the real stakes are of constitutional disagreements. But I would also say that it's not just ignominious principles that have this quality of transformation over time. So in the Canadian context, for example, and this is something that has overlap with a lot of different constitutional jurisdictions that have identified good unwritten constitutional principles, we see democracy recognized. And yes, there's a way in which you could draw a line from the beginning of either the Canadian or the American constitutional polity and say democracy has always been there. But there's another way in which you could say democracy has absolutely not always been there. There have always been large constituencies that have been excluded from the franchise within these jurisdictions, notably on the basis of indigeneity in Canada and on the basis of race in the United States, now arguably on the basis of racially coded laws respecting incarceration and felony status. So I think it's these ignominious principles absolutely have a temporal quality and a give and take over time. But I think that's not introduced by recognizing the existence of ignominious principles. I think that's something that's true about constitutional principles already, and that thinking about the ignominious principles helps us see more sharply. Thank you for that really helpful question.
Thank you. I'm delighted to call on Professor Decca. Thanks for joining us, Manisha.
Thank you, Doug. Thanks so much, Jessica. That was just wonderful. And I'm just wondering about my own kind of constitutionally laced project and what your thoughts are, because I would just love to have your take on this. So in Canadian other contexts, as you were mentioning, right, like the rule of law is one of these unconstitutional principles. And so as you may recall, I'm presently thinking about how to mine this principle despite all its kind of tainted baggage, for positive reform for animals. So, along the lines of saying, kind of government abdication for animal use and or allowing industry to self-regulate is really a rule of law problem, that we should understand it that way. So how do you see that argument kind of gelling with the animal exploitation principle, which, I completely acknowledge and agree with you. So how would you kind of reconcile those two? Or another way to put the question, do you think it's possible to advance the argument that, like, to still try to work with the rule of law, given its incredible take-up nationally, domestically, and international law, in favor of animals, in the face of an unwritten animal exploitation principle?
So thank you for this question, and I'm really delighted to talk about this in connection with your project. So I've thought about this more specifically in connection with Linda Collins has written a lot in Canada about the idea that, sometimes writing with Lauren Sawson, about the idea that we should recognize an unwritten principle of environmental protection or environmental sustainability, rather, as existing in Canada. And this is kind of the closest thing to a discussion of unwritten constitutional principles touching on animals that I could find. But it was taking a take closer to what you're advancing, trying to harness these ideas of unwritten constitutional principles to put forward a positive vision for change in favor of animals' interests. And I really try explicitly to emphasize that by pointing out these unwritten constitutional principles like animal exploitation, it's not meant to suggest that the good or positive principles that have been identified are bad or useless. Instead, I want to suggest that there's a contest to be had, a conversation about what these principles are and what good they do. So I think identifying, it's certainly not my intention to say democracy, rule of law, get rid of them all, it's all the same thing. I think it's possible to see rule of law and democracy and these other principles as having important positive valences, not just for human beings, but also for animals. And I've written in the past about the relationship between democracy and animal protection, and really think that it's important for scholars to find ways to articulate the interests of animal protection using these really core values and institutions. So I would certainly not view a rule of law based animal protection project as being at odds with the existence of an animal protection principle. Instead, I would suggest that the idea that there are both ignominious and sort of more vaunted unwritten constitutional principles creates space for a richer account of the place of rule of law in understanding animal protection, because it lets us acknowledge that rule of law really should not require the kinds of private articulation of standards and other things that you've been criticizing from a rule of law perspective. So then how do we explain how a country that does value rule of law acts this way? And I think the animal exploitation principle helps to kind of square that circle and it helps to articulate the choices and decisions that we're making between principles that we say we value and principles that we don't admit we value, and renders articulate a debate that otherwise happens far below the surface. Thank you for that.